Welcome to today's program titled It's Not You, It's Me, Termination Clauses on Federal Construction Projects, the 10th session of our Winning Combinations webinar series. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email that you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Sarah Barney. Sarah, you may begin.
Thank you so much, Sadie. Hi, everybody. My name is Sarah Barney, and welcome to Winning Combinations, a Seyfarth government contract series where we explore the intersection between government contracts and some of Seyfarth's other practice areas. Today, I am teaming up with a member of our construction group for an episode titled It's Not You, It's Me, where we are talking about termination clauses. A little background on me, I am an associate in our government contracts practice group. My practice runs the gamut from bid protests to claims to more regulatory compliance work. And I have also dabbled in some more straightforward civil and criminal litigation. I will turn it over to my co-host, Lori, to tell you a little bit about herself.
Hey everyone, good afternoon. As Sarah has previously introduced, yes, my name is Lori Chen. I am an associate in the construction group in DC. I generally help clients with litigating construction claims from like delays and defects and managing construction projects. And so I run the gamut from, small projects to massively large projects.
So if the title didn't give it away, we are going for a terminations as told through some classic 80s breakup songs. Not only do we think it keeps the mood a little light, but we do also think there is some overlap in terms of the framework. A little overview of today, we're going to start by reviewing the difference between federal versus private construction projects and why it even matters. We're going to run through some of the main types of termination, namely termination for convenience and default, and then we will touch on termination disputes and best practices.
I just want to say that it was Sarah's idea to go with the 80s music theme, but and unlike these songs, we're going to give you tools to survive the breakup, legally speaking.
Arguably, the song is. I will push back the song's a tool, but moving to our first topic, what does it mean for a project to be public or federal versus private? And obviously, there's a couple big things here. The customer is one of the main ones. When you are in a federal or public setting, across the table from you is going to be a state or federal government entity or an institution that's using federal or state funds, versus in private contracts, you're going to be looking at private parties. An additional kind of difference that I've touched on there is funding. For federal contracts, your funding is going to be coming from taxpayer dollars, which is one of the foundations for all of the different requirements that we will run through. Versus for private contracts, you're looking at private money. So more personal skin in the game. I think some other big differences to touch on before we move on to the meaty stuff is the fact that there are differences in the procurement process. I think as Lori and I were talking earlier, one of the big through lines of this is just there's just more regulation for federal projects. There's going to be more requirements for procedurals, for kind of procedural hurdles. There's going to be potentially performance requirements that relate to subcontracting and labor disputes and potentially needing requirements to register on federal websites. So I think one of the main differences is just the effort that it takes to do business with the federal government. But bringing it back to terminations, Lori, why does the difference between public versus private matter when it comes to terminations?
In private construction, contracts are, governed by whatever's in the contract, and that's state law. So like termination rights from the get-go are negotiated between the parties and clearly spelled out. And so there's so much flexibility in private construction projects because of this.
Absolutely. And I think that's a big difference that you're looking at, is that the Federal Acquisition Regulation, or the FAR, is going to govern federal construction projects. The FAR is going to lay out everything from what has to go into the solicitations and how the procurement process works to what goes into the end contract. And I think another big difference between private and public is that there are certain kind of like legal loopholes in the federal world where even if a term isn't in the contract itself, the government will read it in, or a court will enforce it as a matter of law, just because it's so important to the procurement process. And that's a concept called the Christian doctrine when it comes to federal procurement.
Yeah, so private contracts just, again, have so much more flexibility. There aren't these overarching rules, but just what was negotiated in the contract between the parties. And the risk of termination rights aren't really just well defined, only defined by how you have defined them. We're going to go through the termination for convenience as well as termination by default, but another avenue of termination, at least in private contracts, is this idea of even termination, automatic termination, because automatic termination can be, a clause you have in a construction contract that says that, the contract terminates if certain event happens. A really common example would be like a monetary event, like we didn't hit a monetary event, and thus the contract is terminated. I'm going to volley this back to Sarah, so we're going to get started on the more interesting parts of our breakup, termination for convenience.
So a termination for convenience is the government's way of saying it's not you, it's me. It is a mechanism for the government to stop a project without the contractor having done anything wrong, simply because the government considers it in its best interests. Now, terminations for convenience, or T for Cs, as they're sometimes called, are required in all, a clause giving the government this right is required in all federal construction contracts. And this kind of circles back to what we were talking about a few minutes ago, that even if it doesn't make it in your contract, a court will read a T for C clause in as a matter of law under the Christian doctrine. Notably, these terminations can be in whole or in part. So a government agency might decide they just don't need some of the work done and have you move forward with other aspects of it. And finally, the terminations for convenience, as I said, are based on what the government considers is its best interest, which is a pretty broad pool of things. There are some restrictions, which we will talk about later, but notably terminations for conveniences do give the government a lot of flexibility. Well, to Lori's point, private contractors have a lot of flexibility between the parties. The government has a lot of flexibility only on its side of the table when it comes to terminations for convenience.
Sarah, that sounds like a very one-sided relationship.
Oh, you're getting the theme down.
well, back to my theme of private construction projects being, filled with so much flexibility. Yeah. In private contracts, termination for convenience, you'll see more often in bigger, large-scale construction projects, which will then usually reserved more for the owner, and it must be explicitly stated. I should also note that it gives the owner a lot of flexibility, and it avoids the difficulty of proving someone's breach. But the contractor is generally able to recover costs associated. But there's this idea that an owner can just terminate if they can find a better price. And that there's case law that suggests that in the absence of that clear warning, exercising a termination for convenience clause simply because you can obtain a better price from another party actually could amount to a breach. So watch out.
Which I think, to your point, is a pretty big difference between the public versus private in terms of there needing to be a better justification than I want to get it from somewhere else cheaper when you're in the private realm. Something that Lori touched on was the recovery of costs. And I think that is a big question. If the government just up and ends part or all of your contract, what can you recover? So from the date upon the receipt of your termination notice, you as the contractor have a couple obligations that are laid out in the FAR. You have to stop work. You kind of can't create more work for yourself, but you also have 1 year to submit a cost proposal to the government. And in that cost proposal, you will add up the costs that you incurred in performing the terminated work, which might include some prep work, the costs incurred for paying out and settling any downstream subcontractors as a result of the terminated work, any reasonable costs of kind of getting your settlement together. And then there's a pretty broad category of additional sums determined by the contracting officer to be fair and reasonable. So if you can get, I think that's a place where you can potentially try to recover more costs. I will say generally there is no payment for anticipated profit on unperformed work. So unfortunately, that is not a pool that you are likely to be able to recover in the event of a T for C.
And for private contracts, generally, I feel like I'm just harping the same thing, which is, there's a lot of flexibility. It matters what you negotiated at the front end for this termination for convenience clause. But, generally there is the terminated party is entitled to recover costs incurred or, demobilization, and just like sorting out and settling out the subcontractors. But again, back to my theme with the private contract is, what did you negotiate in the contract for the front end?
And back to my theme of the government has a lot of power. Terminations for convenience do appear to be pretty limitless, but they can be contested by a contractor if the determination to terminate for convenience was arbitrary, in bad faith, or procedurally flawed. So an example, terminating after performance was completed is not gonna fly in the court system. Additionally, a termination for convenience doesn't eliminate the government's obligation for liabilities for events that preceded the termination. So, for example, a T for C doesn't erase a prior claim for an equitable adjustment. So T for Cs can feel like the government kind of has the world on a string and can jerk you around, but you do have a couple avenues to cabin that in.
So what you're saying is that if the government walks away from the project, it's not like mid-project, it's not always a clean break, and you may be entitled to recover, but only if you follow all these steps we were just talking about.
Absolutely. And obviously it's more nuanced than what we are touching on now. Each case is going to be different and you're going to want to consult an attorney about your specific circumstances.
Next slide. So now we're going to touch on termination for default. It's a legal equivalent of saying you messed up and now we're done. In private contracts, either party can terminate for breach just as long as the breach was material.
Similarly, the government can terminate for default because of a party's actual or anticipated failure to perform. That could be failure to meet completion deadlines or make adequate process. It could be abandonment or any statements or actions that amount to anticipatory repudiation of completion of the contract, or finally, a material breach of the terms and conditions that are specific to the contract themselves. And my old chorus here, in federal contracts, terminations are governed by the FAR. Terminations for default are specifically governed by FAR 49.4, which outlines a few factors that the government is required to consider in determining whether to terminate a contract for default. There are 7 specifically enumerated factors, a few of them being the specific failures of the contractor, the availability of the supplies or services from other sources, how urgently the government needs the supplies or services, and once again, the government leaves itself a nice little catch-all, any other pertinent facts and circumstances. So I think it's kind of this push and pull theme that we've talked about where the government has a lot of flexibility, but there are certain both procedural steps, and the FAR here establishes some kind of substantive analysis that the government has to perform before it pulls the trigger on a termination for default. I think another thing that is somewhat unique to federal versus private is that if the default is based on a failure to perform a contract provision, like not furnishing a performance bond or failing to make progress, the government is required to provide the contractor a notice to cure in writing and to give the contractor the opportunity to kind of correct the basis for the default, which is at least 10 days, but could be more.
Similarly, private construction contracts usually have the same notice and cure when there is a suspected breach. Sorry for that. And again, back to my main theme, private contracts can be negotiated. So this would have been negotiated in the contract, which is if there is a breach, this is the procedure you must follow. And usually that is a notice with a opportunity to cure.
Absolutely. I think something that federal contractors on construction projects also need to consider is the impact of a default termination on their performance and payments bonds. Under the FAR, there are certain penalties that come about in the event that you are terminated for default. Additionally, in a government-initiated termination for default, the defaulted contractor can actually be on the hook for the cost that the government incurs as a result of the termination, which could include reprocurement costs, like finding another contractor and having that contractor complete the terminated work, or liquidated damages.
In private projects, there's a lot of ways that you can get terminated for default for breaching the contract. You could not perform the work, there could be defects in the work, or you're delayed in the work, all the host of these reasons for such breach, and then the associated damages that one would seek for that. But again, you must be able to prove the breach and then quantify the damage.
So we've talked a lot in the default setting about what the government can recover or kind of what the non-breaching party can recover, but there is potentially an avenue for defaulted contractors to recover some amount of money. There have been some recent cases, recent is a relative term, one in 2019 coming out of the Court of Federal Claims called Eludic Manufacturing Contractors versus the United States, which provides a really good example of how courts evaluate the reasonableness of a termination and potentially their openness to awarding even defaulted contractors some recovery. In that case, the contractor was awarded a firm fixed price construction contract to repair asphalt for roads on an Air Force base. There were performance issues from the get-go, but none that the agency saw as kind of preventing timely performance. The Air Force sends the contractor a couple cure notices. In response, the contractor takes a lot of corrective measures. They develop a recovery schedule to try to get back on track, and they actively are working to kind of get back on schedule. Before that can happen, the agency terminates the contractor, but at the court, it comes out that the agency didn't fulfill one of the required FAR steps in determining whether a termination for default was appropriate. Specifically, they didn't look at a critical path analysis of the recovery schedule that the contractor had come up with to figure out whether or not the contractor could still feasibly perform. So in this case, the court found the termination was unreasonable based on the government's failure to follow the factors outlined in the FAR. And the standard for default that it's default appropriate only when there's no reasonable likelihood that a contractor will be able to perform the effort within the time remaining for contract performance. So there is a light at the end of the tunnel for contractors who are looking to either dispute a termination or to kind of figure out their way to get to recover some of what they've invested in a project.
So before you quote, go your own way, make sure that you have all the facts, like the notice and the documentation to back all of this up. I feel like that's what I just learned from your case. Next slide.
Okay, so getting to termination disputes. Love may be a battlefield, but so are termination disputes.
So are your 80s love song puns.
We've cashed the bank. I'm running out of them. So for federal contracts, something unique about termination disputes is there are limits in where you can go to recover and how you have to recover. So termination disputes are governed by the Contract Disputes Act or the CDA, which limits some of the forums you can go to. Contractors can generally appeal terminations at the respective contract boards of appeals. So for example, the Civilian Board of Contract Appeals, or they can go to the Court of Federal Claims. But as we'll touch on later, deadlines matter and might be considerations in which forum you go to.
In private contracts, I mean, I think it's a little bit more obvious. These disputes usually get resolved through litigation or ADR, whether it be arbitration or mediation. And the contract should specify the forms and the procedures and where to go with this. And the same general contract rule applies, with statute of limitations, warranties, etc. Again, generally the contract will tell you how these disputes will progress.
You have less ability to pick and choose your forum and your mechanism for disputes when it comes to the federal government. For federal contract, appeals of terminations have to be filed within 90 days if you end up going to the board, or 12 months if you go to the court. I think this is another place where there's a lot of procedural nuance around how to bring a claim. I think Lori and I, in kind of our prep work, we're talking about, Lori was like, well, you bring you sue. Like we were laughing about it, but Lori says in private contracts, I don't know, you sue. But there are several procedural hurdles you need to get through to bring a claim under the CDA. That could be, and maybe should be, a webinar in itself, but one of kind of the hallmarks of a CDA claim is you need a contracting officer final decision, which is a term of art. And notably, terminations for convenience do not automatically give you a right to appeal. You must first go to the contracting officer and get a contracting officer final decision on the termination for convenience before you can challenge it. So there's no automatic right to challenge a termination under the CDA for a termination for convenience. And we saw this, and this one is recently, we saw this really recently at the Civilian Board of Contract Appeals. There were 2 cases in January of this year of contractors bringing claims to the board related to a termination for convenience. In John Blankson, the board held that a contracting officer termination letter does not bestow jurisdiction upon the board to hear a claim. Once again, the contractor has to go through that step of getting, among other things, the contracting officer final decision. That same month, the board decided a case called Tesla Liliana Reyes Ramirez. And I think this one's interesting because the termination notice itself said that the decision was appealable to the board. And the board bounced that back and dismissed the case because they said kind of that who decides who gets jurisdiction doesn't come from the letter, it comes from kind of the jurisdictional hooks. And unfortunately, until you have that contracting officer final decision, you do not have one. So I think that, to the extent that we're singing the same refrains, mine is that you are going to be looking at more regulation, which in some ways can be nice. There's potentially some more predictability about how things have to happen in the federal realm versus the Wild West of private contracting.
I wouldn't necessarily call it the Wild West. I mean, just negotiate it on the front end. But yeah, I guess the negotiation part could be the Wild West.
Lovely. Next slide, please, Sadie. Okay, I will survive. This is our best practices when it comes to termination. And I think one of the big points is from the federal contracting side is knowing your rights. I think while we've said that some are just going to automatically be read in as a matter of law, it's important to know who can terminate, how they can terminate, and in the case of federal contracts, what procedural hurdles stand in between you and potentially recovering in the event of a termination.
And, I've been harping on this for the last 20 odd minutes. The most important thing in private contracts is, knowing your termination rights, negotiating your termination rights, and having all of that on the front end so that you have a very good and clean contract.
I think another one, and we'll skip around the order here, is documentation is really going to make or break your termination claims. I think Alludic is a really good example of a place where the contractor heavily documented what they were doing to try to respond to a cure notice, and that kind of saved them in the end because they were able to show what the government should have considered in coming to its termination consideration. That being said, documentation is going to matter when it comes to building your cost claim. If you are trying to dispute a termination, it's going to be important to have a record of what did or didn't happen, or kind of the steps you were taking to perform with to comply with the contract requirements. So document.
I mean, same thing for the private contracts. It's ditto what Sarah said, which is, yeah, documentation matters. You want to be able to, if you go down the road of litigation, that you have all the records, you have all the paperwork, that showed that, this was the notice, there was the cure, etc. And, again, documentation matters.
Absolutely. And I think kind of the sister to documentation is potentially communication. So making sure that whether it's a private contractor or a contractor reaching out to the contracting officer, making sure that you're clear about expectations, about when you've been terminated, what constitutes a termination. And I think that's a place where the communication can form the foundation of the documents you're assembling in order to support your, I think probably more so on the litigation side than the cost side, but that communication is important for knowing where you stand and also potentially heading off a termination.
Yeah.
Lovely. Next slide, please, Sadie. Well, thank you all so much for joining us today on this episode of Winning Combinations. Thank you to Lori for lending us her private construction expertise. She's going to read off the CLE code, and then we can look at any questions to the extent we've gotten any.
The attendance verification code for the CLE is SS0598. And, you know, Sarah, to reiterate, Sarah, thank you so much for joining us today. And obviously, if you're facing any termination issues, reach out to our team. We're here to help you navigate the legal landscape, even when the music fades. Sarah, you really love those.
I do. Oh, and before we get to questions, if you enjoyed this material, the Seyfarth Government Contracts Group releases a blog called Claims and Sustains. On there, we will cover everything from new developments in regulations or new case law developments, or getting you back to the basics of bid protests and claims. So be sure to check us out there. And Lori, do we have any questions? I am not readily able to see them.
I don't see any. So,
well, we can only assume that we've answered all your questions in these past 26 minutes. So thank you all for joining.
Thank you.